Good afternoon. Thanks for joining us live on Facebook at Reddy and Newman PC here in Houston, Texas. My name's Emily Newman. I'm a partner with the immigration law firm of Reddy and Newman PC. We've been in business since 1997, and I'm here with my partner Rahul Reddy.
Hi, this is Rahul Reddy. I'm a partner of Reddy and Newman PC. We're in business from 1997. We are here to address some of the immigration current issues that are going on right now. Emily, one of the major things that is bothering a lot of people is the quota over for master's quota? What about the bachelor's quota? Is it over or is it still there?
Yeah, we're definitely still expecting receipt notices to come in. In our experience, USCIS will normally send an announcement explaining that data entry is complete, and after that point, receipts will trickle in for the next few days, and then it will be over. So it's certainly too early to expect it to be over for either the master's cap or the bachelor's cap, and we should be expecting an announcement. You know, last year the data entry announcement was on May 3rd.
Yes.
I feel like we're about 10 days behind
this time
compared to last year, so it might be another week before we see that data entry announcement. We've just started receiving some of the regular non-master's cap receipts in the mail this week, so those will continue coming in, I expect, over the next week.
In other words, we haven't received a good number of bachelor's degree receipt notices yet. They are still due. Emily, now the premium processing is not there for the cap cases. We are expected that to be open at least on October 1st, or maybe the USCIS decides to change its opinion. Maybe it's open. When do you expect the RFEs to come in or approvals to come in at this point of time?
Well, interestingly, we've received both today in the mail. So we've already started receiving approvals. We've already started receiving RFEs, requests for evidence, for cases that were just filed in the lottery. So it feels like maybe they're starting the adjudications process a little earlier compared to last year. It seems like last year we were still getting the returned petitions before we started getting the requests for evidence, and we haven't received any returned petitions. That won't happen until probably June at this rate. So yeah, they've started adjudicating these cases, and we should hopefully see more coming in earlier this year. Hopefully we'll be getting most of the approvals for those cap gap individuals by the end of September. And if not, I would highly recommend upgrading to premium processing as soon as it's available, so that you're not stuck after October 1st not being able to work.
Emily, we have seen the new website update with regards to the I-983, where the people who are working on the STEM extension after their OPT period of 12 months, they're allowed for 24 months of STEM extension. And there's a new interpretation on the website with regards to when they are working at third-party placement, and also with regards to how the employers should be training their employees and the rules and rules related to that on the website. Can you educate our audiences on what the deal about is and how it's going to impact on the people who are working at third-party placement?
Right, so we know that when the STEM OPT rule came out that created the 24-month extension with the training plan requirement, USCI, or ICE actually, Department of Homeland Security through ICE, stated that it must be a bona fide employer-employee relationship. And they kind of left the door open. The regulation wasn't clear, kind of the preamble or the beginning discussion when they issued the final regulation did talk about third-party placement, and that perhaps it was not the best situation for a training plan to take place, but it did not specifically restrict it. So now we have a random update on the USCIS website, which by itself is a little odd since it's actually ICE that's in charge of this, but USCIS updated their website saying that third-party placement is absolutely not allowed for STEM OPT only. So apparently it's okay for OPT for the first year, it's okay for H-1B, but if you're in between and on that STEM OPT, it's not okay. And the reason for that is the training plan requirement. They're basically saying that it's impossible for an employer to train someone remotely. which that remains to be seen since we have distance learning in our colleges across the country.
And they're using the drones from Langley, Virginia to bomb the people in Afghanistan and Pakistan. And they're sending satellites all over. I don't know where they send satellites to, but they definitely don't have anybody sitting out there. They're all remotely controlled. But it seems to be that the USCIS has not caught up with the technological aspects of what's going on in the real world. But there are consequences we might face if the person is working at third-party placement. We are yet not sure how the USCIS is going to act. There is a probability that they might say that the person is out of status for the period of time when the person is working at outside the location. We are yet to see any of the interpretations. At this point of time, we have seen that only one university, I don't want to name that university, that is not approving the 983 forms when the third-party placement has been there.
So for someone who's on the 12-month OPT and you're maybe working at a third-party location, if you're getting ready to file your STEM OPT extension, I would recommend reaching out to your DSO well in advance and ask what is the requirement. Are they able to approve the training plan where you're working at a third-party site? And if not, then you can try to make arrangements to work in-house at your employer's location in order to file the I-765 and get the STEM OPT approved. So definitely don't wait till the last minute. Find out in advance how your school is treating the situation, because we don't have any data from the field yet on how any of this has actually been implemented.
Emily, what about the H4 EADs? We have been speculating that in June we are expecting some new regulations on H4 EAD. Does this mean that H4 EAD does not exist from June, or what exactly is expected from the H4 EAD? Can we file the H4 EAD extensions? Can we file the H4 EADs at all right now?
Yeah, you definitely can continue filing. I would recommend, if you don't have an H4 EAD and you're eligible for it, go ahead and file for it now, because it's very likely, in the event that some new regulation is finally published and becomes final, that those with existing EADs may be allowed to continue on them until they expire. So if you can get a 3-year H4 EAD right now, go ahead and do that so that you're good for the next 3 years. Now, this is all speculation. I would say we're pretty sure that we're going to see a proposed regulation, maybe in June. Who knows? It's already been delayed once. So we're expecting a proposed regulation. That proposed regulation is meant to get rid of the H4 EAD as an option. But remember, it's just a proposal. It has to go through many steps of notice, comment period, review the comments, issue a final rule, let the final rule take effect, and then very likely a lawsuit somewhere in between there. So nothing's going to happen to the H4 EAD overnight. It's going to be a long process. We'll get to know kind of what the intention is probably sometime in June. Could be later than that though, but no reason not to file it right now.
So if you're eligible for H4 EAD, please file H4 EAD. Absolutely no issues with it. And just to remind people that if you had a H1B before and you have the H4 EAD, you can always convert back into H1B if you have time period left in the H1B within the six-year period. And also, if you are in H4 EAD, you can file the labor certification on I-140. It does not preclude you from filing. You could still file the labor in I-140. So if you're coming very close to expiring the H1B and then you have moved to H4 EAD, this is the right time for you to file the H4 EAD. As Emily has pointed out, even if the regulations are going to come up, they're going to take a long time for them to be interpreted and come into practice. So in the interim period, you could still file for the H4 EAD. And we are expecting that the existing H4 EADs will not be taken off immediately. They most probably will come up with a proposal where they are not going to allow to file the extensions. That's what they did with the undocumented aliens called DACA kids, where they did not allow them further extensions. They didn't say all EADs are invalid. They only said that the further extensions, they're not going to do it. And that still is challenged in the court, and they're still filing the extensions. That's a different story altogether.
All right. Somyadip asks if there's any reason not to file an I-140 in premium, or if you should file it in premium.
There is a misconception that people are going to get an RFE in premium processing. That is not true. That is not verified. It's not true in the H-1B. It is not true in the I-140. If you have the eligibility to file a premium processing in the I-140, I don't see a reason why you should not file a premium processing. I know it's going to cost a little bit money for you, but it's worth for you to get it because your spouse can get an EAD. Right now, there is a limbo with regards to the H-4 EAD. This is the right time for you to file an I-140. Once you get an I-140 approval, you already know that your spouse can get a H-4 EAD. No reason not to use the premium processing. Emily, the questions are coming with regards to there is a shorter duration of the H-1Bs. Now, previously H-1Bs were being given for 3 years, and when you are eligible for only 1 year extension based on your labor certification pending, or when the I-140, if your I-140 is approved, you're eligible for 3 years, we used to get the 3 years H-1B extension. All of a sudden, we started seeing the 1 year extensions and 2 years extensions, and in some cases 3 year extensions. But now the clients are seeing a shorter duration, sometimes 6 months, 4 months. Sometimes the H-1's approval is coming on April 30th, but the end date is April 19th of 2018. So can you explain why they are doing it and how we can get over with those things?
Yeah, first I would say it's definitely not across the board. I mean, it's happening, yes, but I would say 90% of the time this is not an issue. For the remaining 10%, it may be an issue where the documentation does not show that there's sufficient work available for the full period of time requested. So anytime you're filing an extension, whatever period you're asking for, you always have to document that there's sufficient specialty occupation work for the full period you're requesting. If that is not being documented, that is the situation where the approval might come for a shorter period. Yes, it is happening. Yes, they're getting shorter than they used to be. Usually it would not be less than a year. Now we're seeing a few here and there that are less than a year. But it's certainly not something that is happening across the board.
My H-1B is picked, but I'm not working with that company. Can I change to the company that I'm working for right now before the H-1 approval?
Well, depends on a lot of issues there. Assuming that you are authorized to work for that company, I don't see a problem with switching. However, it makes me a little nervous. Why would you be filing an H-1B petition with a company that you're not working for? Maybe that's a duplicate filing. So I would definitely consult an attorney before you take any action there. Any issues? This is based on an I-485 application. If someone recently filed the 485, maybe the priority date became current recently and already knows there's a request for evidence coming on the 485, is that going to delay the EAD-AP combo card for any reason?
We have noticed that if it's an initial application that had been filed, in other words, you file 485, you file a 765 and I-131, we have noticed a longer period of time for getting the I-131 and 765 adjudicated, up to a period of 180 days. Now, previously it was only 90 days. When you're filing for an EAD extension or I-131 extension, the period is only 90 days, but when you're filing initially, and if there is an RFP on the 485, we are seeing a delayed 765 and I-131 approvals right now, which is a very recent trend, I would say in the month of April and May of 2018.
All right. Srinivasan asks how long it takes for a motion to reopen. That really just depends on what kind of case you're trying to reopen, what the reason is. I had some that get approved in a month, some of them take 8 months. Could be anywhere in between. There's no specific processing time for a motion to reopen or an appeal. So it's just a matter of waiting for them to process it, unfortunately.
Sometimes we have seen that if it's a clear clerical error by the USCIS, they do act a little bit more faster than when you're actually going to the depth of the application. Then it will take a longer period of time. That's just rare. I mean, not all the cases, but in some cases I noticed that, Emily.
Mm-hmm. Gauthami asks if she has a valid H4 EAD till, let's say, October 2019, and her husband's filing a transfer. Can she go ahead and file an H4 EAD renewal now?
We have noticed that even though the H4 EAD you can only file for 120 days, but when your husband is filing for the H1 extension, you can file the H4, you can file the H4 EAD. We have noticed that they are adjudicating the cases, they are approving the H4 EAD, even though your H4 EAD is expiring way beyond 120 days. If you would have filed a separate application, that is a different issue, but if you're filing along with the husband's application, I would file it. There is a chance they might deny it, but I have not noticed that at this point of time.
All right. Does an individual have to be in the U.S. to file an H4 EAD?
Yes, they have to be in the U.S. for filing a H4 EAD. You are eligible for H4 EAD only if you are an H4. You are not a H4 if you are outside the country. You have to be in the country to file for the H4 EAD. But once you file the H4 EAD, your travel will not interrupt your employment authorization document adjudication. So you can travel at that time.
All right, still lots of questions asking about whether you should upgrade an extension of an H-1B to premium. Yes, get it over with. Don't wait. It's taking forever. Don't sit around waiting for a year for your H-1B extension to be processed. Upgrade it to premium yesterday, please.
Yesterday. There are a couple of problems here if you don't file premium. One, it's taking 8 months for adjudication, and if there is an RFE, there is another 8 months plus the lawyer's time to respond to the RFE. If you have the I-94 validity, even if you get a H-1B denial, there will be a lot of options open for you. When your I-94 expires, you're going to lose the opportunity a lot. That's the reason why Emily is recommending to file in premium processing. Also to note that when a H-1B extension has been filed, if the I-94 expires, you can only work for that company for 240 days after the I-94 expires. So if you don't do premium processing, in other words, you just sit at home, you don't work. I don't know why somebody chooses that. Somewhere misconception, I don't think so clients are worried about the premium processing fees, Emily. It's just they're scared that just because the premium processing, they're going to get an RFE denial in the H-1B and RF.
It's not the premium processing that's causing the denial.
Please make a note, please.
Have you been getting 485 approvals lately?
A lot recently, very significantly. We've had a very significant number of RFEs issued with regards to the medical, J supplement, and there are a good number of green cards that are getting approved, particularly in the EB3 criteria. As you probably already noticed that EB3 has moved very significantly, so we are noticing a lot of approval in EB3s.
Okay, if you've spent some time on H-1B before, how do you get a fresh 6 years? If you wanted to go through the lottery.
Without going through the lottery?
No, if you want to go through the lottery. I'm not sure why you want to do that.
If you have used up the 6 years of H-1B, if you have used up the 6 years of H-1B, for you to get a fresh 6 years, the only way you do is that you go outside the country, you spend 1 year outside the country, and you apply under the lottery system. By going into F1 visa, by going into H4 visa, you cannot resurrect your H1B. You cannot get a new H1B. You complete 6 years. But there's one hope though, Emily, is that if they are eligible for H4 EAD, they can use the H4 EAD and file the labor certification I-140 approval and then resurrect the H-1B beyond the 6 year period. That's one hope that they have. But if you want a fresh period, the only way is to go outside the country and stay there for 1 year. Outside the country doesn't have to be, meaning it has to be in India. It could be Mexico, it could be Canada. There are some other non-immigrant visas that require that you have to go into home country. But in this H-1B, you can be in Canada, you can be in any other country.
Can someone who's on the H-4 EAD have their employer file a labor for them?
Absolutely. There's no requirement that the person has to be an H-1B to file a labor certification. On H-4 EAD, you could file a green card application. Absolutely, that's an advisable thing. It's a very good option. Emily, do you recommend to go for stamping? Is the Dropbox still available? There was a rumor when the Trump administration came in that they stopped the Dropbox. Is Dropbox still there? Do you advise people go for stamping?
It's still there, but even if you are eligible for it and you use it, you may still be called in for an interview. And I still don't recommend going for stamping regardless. There's just too much of scrutiny going on right now to where you're going to get a 221G, you're going to be stuck in administrative processing so long that you might lose the job. So it's just not worth it.
Question from Raju, Emily, is that right? On the HR 392, as you know that Indians have been waiting for a long period of time, there is no way for them to get a green card under the current circumstances. Their only and last hope for them is HR 392. Which eliminates the per country quota limit for the audiences. That means that the backlog for the Indian nationals will drop from about 10 years to about 3 years, and so on and so forth. So what is the status of it? What are the chances for the HR 392?
Well, it's certainly got a lot of support in the House, probably the most co-sponsors of any bill I've seen, but no one is putting it to the floor for the vote. It's just stuck. And I think that we kind of had our chance for immigration reform with the budget renewal and the DACA and all of that. It didn't happen there. Now the Trump administration from then moved on to tax reform. Right now I believe it's infrastructure they're working on. So we'll have to kind of wait until immigration becomes a topic again and push for it some more. So there is support for it. It just is not getting to the floor for a vote, unfortunately.
Emily, one other issue with regards to when a person is applying from H1 to H4, does he have to stop working immediately, or can they continue working until the H4 is approved? Their H1 has a validity period though.
Right, so if the H1 continues to be valid and you're continuing to work for that employer under the terms and conditions of the H1B, yes, you can keep working on the H1 while you're waiting for the H4 to be approved.
One other thing, if the I-140 has been approved and it's been approved more than 180 days, if the employer withdraws the I-140, can that I-140 still be used for extending the H-1B? Can the I-140 be used for porting the priority date? Can that withdrawn I-140, which was been withdrawn after 180 days, can be used for filing the H-4 EAD?
Yes, under the regulation that came out January 2017, as long as the I-140 has been approved for more than 180 days before it is withdrawn, if you leave that company, you can still use the withdrawn approved I-140 to get H-1B extensions beyond the 6-year limit. You can still port that priority date to a new I-140 that you file with a new employer, and your spouse can continue to get H-4 EADs based on a withdrawn approved I-140.
Sanath has an issue here. He is from Bangladesh. Good, and that's very good, because the waiting period for Indian nationals is going to be 108 years, and for you, it's 0. I'm doing an electrical engineering master's degree. What are the possibilities of getting through EB2?
Well, once you graduate, if the job that you're being sponsored for requires a master's degree in your field of study and you have that master's degree, then they can sponsor you in the EB2 category, and your labor certification I-140 can be filed and approved, and probably your 485 filed before you even run out of STEM OPT time. It's very possible to get the green card and never need an H-1B if you're not from a backlogged country.
Yeah. Emily, one thing that I've seen an article on your immigrationgirl.com, what if my H-1B got selected? So there are a couple of issues that I want you to answer those things. Is that, can you explain the cap gap period? Does the student need to do anything to do the cap gap? That's number one. I'll go on to ask more questions as well.
All right. So the cap gap is automatic for those that have an OPT that's expiring between April 1st and September 30th. If your H-1B is filed requesting a change of status and is selected, you're automatically eligible for the cap gap, which allows you to continue your OPT and keep working, stay in the country through September 30th. Now, even though it's automatic, your employer will very likely need proof that you are authorized to continue working beyond the end date of your OPT card. And you can get that proof by obtaining a new I-20 from your school. Now, if your H-1B, you don't know if it's selected or not yet, but you have proof that it was filed, your school should be able to issue you an I-20 that extends your OPT through June 1st. If your H-1B has been selected and you get the receipt notice, you should be able to get the I-20 good through September 30th. Note that the cap gap ends on September 30th, so if your H-1B is not approved by September 30th, you have to stop working until you get the approval.
Does it mean they are illegal to stay in this country?
No, you're still in a period of authorized stay at that point, which is not exactly the same as status, but you can still get the change of status to H1, but you cannot work after September 30th based on the automatic cap gap.
My H-1B has been selected in the lottery and I'm working with the end client A. Now I lost the job there. I have to move to the end client B and he is in a different state. It is from Florida. I have to move to California. Will my H-1B be approved?
This year, probably not. I don't know how you'd be able to get it approved, unfortunately.
Yeah, unfortunately, if the premium processing would have been there, that would have solved for a lot of people. This is going to be a lot of issues, particularly people who are moving end client locations in the interim period of time. While the H-1B, you're going to be in trouble.
All right, what other questions did you have on the cap gap?
The cap gap, Emily, is that one is that that if the person is you said that you already covered the September 30th. After that, they cannot work. The job change, if they have a job change, they're going to lose the H-1B for that. I got my H-1B approval in the new quota. Can I change the job right now before October 1st?
To a new employer?
Right.
Technically, yes, because you're still on OPT at that point. However, you don't want to run into the situation where you leave that company and they then withdraw your approved H-1B and you end up no longer counted in the cap. So it's a very risky thing to change employers prior to October 1st, even once your H-1B is approved. Better to wait and do it on or after October 1st and file a H-1 transfer to move to that new employer rather than trying to do it before October 1st while you're kind of in that in-between period.
There's also one other danger, Emily, is that right? That when the person moves from F1 to H-1B, they get kicked out of the service system. So once the H-1B has been withdrawn, they cannot even go back to the F1, they're out of status. So that's going to be a big problem. You try to avoid that as much as possible if you can.
Yeah, also on that, on the cap gap. So if you're in a situation where you've got the cap gap, your H-1B was selected, now it's September 30th, your H-1B is still pending, and you're not upgrading to premium, even though we don't recommend not doing that, be aware that if you end up to where your H-1B might not get approved, your grace period is going to be ending on November 30th for your F1 because you have your OPT ending September 30th. Now you're in your 60-day grace period. So even if you're in a period of authorized stay based on the pending H1, if your H1 might get denied, you might want to consider using that grace period to re-enroll in school, obtain a new I-20 prior to November 30th. If you wait until December and then your H-1B gets denied, you're out of status. No F1, no H-1, you're done.
Venu has this question. My H-1B extension has been pending for 11 months. Do I need to upgrade to the premium processing?
Please.
And why?
If you're filing an H-1 extension with the same employer, your I-94 expires while your extension is pending. You're only eligible to work for 240 days. So if you're going on 11 months now, you're probably past the 240-day mark or getting close to it, depending on how early you applied for your extension. So you either need to file another extension, which is just as much money as just upgrading it to premium. And also, you don't want to be in a situation where your I-94 is expired and then you end up with a denial.
Yeah.
It's much better to file the extension in premium well in advance. If it's going to get denied, at least it happens before your I-94 expired, and then you can continue your status until that I-94 expired and figure out what other options you have. But once you get to this point where your petition's been pending for months and months and months, your I-94 has been expired for months and months and months, your options are limited. You're limited on getting a new job if you want to file a transfer. How are you going to file a transfer if you don't even have an I-94? You can't do anything. You're stuck. So please upgrade it to premium processing.
It's an absolute lie if anybody is telling that premium processing has a greater chance of RFE or denial. Don't believe them. Don't trust them. Please don't ruin your life by not filing premium processing. Mr. Sachin Soni has a very good question, Emily. Can a person port the date from AB2 to AB1? That's a good question. Can a person port from EB, and this I'm going to continue more asking questions. Can you move to for EB3 to EB2 and also vice versa from EB2 to EB3?
Yes, short answer. Hopefully you wouldn't need to port the date to get into EB1 because it's generally current, except for that little bit of time.
Right now it's backlogged by 6 years. EB1 is backlogged by 6 years.
But yes, you can port the date. You can downgrade from EB2 to EB3. Those of you that have been watching that EB3 date move faster and faster and faster while EB2 is slower and slower, a lot of people are considering preparing to file an EB3 I-140 based on the EB2 labor certification, and that is an option. And then once whichever date becomes current first, you get to proceed with either one.
Samyudip has a good question. My I-140 has been approved. I'm going to move to India. Will the I-140 remain valid? If the I-140 has been approved for more than 180 days, even if your employer withdraws your I-140, the I-140's priority date is with you all life. I have had a case where the person left the country for 10 years. He came back on H-1B. He had an old I-140 which was never withdrawn. I resurrected the old priority date and filed the adjustment of status. Absolutely no problem with that thing. Now, if the employer wishes that I-140 be not withdrawn, he can continue it. You can still get the advantage without filing another I-140. But mostly what happens is that when you leave, the employer is forced to withdraw the I-140. But even if he withdraws, you can still port the priority date. Anything else, Emily?
Let's see what else we have here.
H4 validity, what is it H4 validity? H4 EAD validity will be based on. H4 EAD validity will be based truly on the H4 validity, which will be interlinked with the H1B of the spouse. So H1, H4 will be valid for the same period of time, and the H4 EAD will be valid at the same time. Also, to remind people that a lot of lawyers have not filed H4 along with the H1 applications in the quota. If your case has been selected in the lottery and you have a spouse who is on a different visa status, you need to apply for H4 right now. As soon as your H1B gets selected in the lottery, if I were you, I would file for the H4.
All right, we have a question about a job loss while you've got an H1B in the cap pending, you've got your OPT. What can you do if you're let go before your H1B is approved? Best case scenario is to work with your employer to not withdraw the pending H1B and hopefully get an approval.
Without RFE?
Without an RFE if you're lucky. And then on October 1st, transfer the H1 to your new employer. If the employer is not willing to continue the H1B and they withdraw it, you are no longer counted in the cap. You've got to go through the lottery next year. You've got to keep maintaining your OPT or go back to school, whatever you need to do to maintain your status. But that's definitely a tough situation to be in.
Same repeat questions.
Radhakrishna has an interesting question. What is the DOL looking at when they approve LCAs? Practically nothing. It is a very cursory overview to make sure that you're not asking for more than 3 years, that your wage is not below the prevailing wage. I think that's about it.
I have seen some. I've seen some weird and funny LCAs that were put in some not so good anti-immigrant websites, saying they got LCA approved for higher level positions for $20,000 salary and all those things. That might be true that the Department of Labor is not checking into that very carefully. But let me tell you one thing. USCIS is not going to approve your petition. They are looking into the SOC codes, they are looking into the salary, they are looking into the prevailing wage, they are looking into the job description tallying. Though that anti-immigration site has listed it out on there citing the LCA, the USCIS does not approve based on wrong LCA. Practical, the DOL, as Emily was pointing out, is only looking into the clerical things, but the USCIS is looking into the LCA codes very, very, very thoroughly.
All right, Himanshu is asking if you're on the H-4 EAD and your employer does file a labor certification for you, if the H-4 EAD goes away, do you lose your labor certification?
Assuming if the labor and I-140 has been approved and it's been more than 6 months, no, you don't lose the priority date. It will be with you forever. But if just the labor is approved, most probably the company might not be willing to continue to file the I-140 because there is no job for you, so they might not. But if the labor and I-140 has been approved, you have it with you. And if it's more than 6 months that the I-140 validity is there, it will stay with you. In other words, if you had a H-1B, you can resurrect. If you get into the H-1B lottery system at a later date and you want to get into the H-1B, you can beyond the 6 years period of time, you can still use the old I-140 approval which has been there for it. So it's going to stay. Once the I-140 has been approved for 6 months, it's going to be with you until your life ends.
All right, we have a question on E3 visas. These are for Australian citizens, very similar to an H-1B except a slightly easier process, and they're only for Australian citizens. They do not allow for dual intent. So where the H-1B allows you to be processing the green card and it's not a conflict with what your intention is, the E3 does not have that, meaning when you're on an E3, you're required to maintain only non-immigrant intent, and you're not supposed to be working towards a green card while you're on an E3. Now, if you're an Australian citizen born in Australia, it may be possible to get the process done fast enough to where it's a possibility. But if you are, for example, an Australian citizen who was born in India, the process will be too long. You may not be able to renew your E3 the next time if you've already started your green card process.
I just want to explain more thoroughly with regards to when it comes to the non-immigrant visa, it's the passport that you hold that counts. When it comes to the green card application, it is the country of birth you are that will count. So just because you change the citizenship will not have any impact on the green card, because otherwise I will tell all my clients to go to some South American country and buy the passports and come back and get the green cards faster. I'm not speaking anything illegal. There are some countries that sell the citizenship for money, but that doesn't entail you to get the green card application faster. So please be aware of that.
Do you have any updates on the ACICS accreditation, and can people who lost the opportunity to do the STEM OPT get it now based on that accreditation coming back?
As I just want to update that the court has given a judgment in April 3rd of 2018 with regards to the ACICS accredited universities that lost their accreditation on December 16th of 2016. But when the court gave the judgment on April 3rd of 2018, they went back and said that the accreditation goes back to December 16 of 2016. All the degrees that were being issued between the December 16 of 2016 to current, they are all accredited. But the problem is that those universities that were not accredited in the interim period, where the people would have been eligible for the STEM extension. Let me explain you. OPT is given for 12 months, STEM extension, if your university is accredited, you're eligible for a period of 24 months. So a lot of kids have lost the opportunity to do the STEM extension at that period of time. The court has not instructed very clearly with regards to what is going to happen on the STEM extension. Most of the people might have lost the opportunity to work in the United States for the 2 years period of time because the government has unaccredited the ACICS universities. Please also note that Silicon Valley University, even though it's ACICS university, lost its accreditation from ACICS completely. So that's not no longer accredited. Even though ACICS is accredited right now, Silicon Valley University is not accredited anymore.
All right, do you think that we should be expecting to get all of the H-1B approvals by the end of September this year for the CAP cases?
Are you on drugs? We have
I'm not.
Okay. We have had some H-1Bs that are still pending until April of 2018 that were actually were from 2017 that if we refused to do the premium processing. So no, not at all. We're not expecting the cases to be adjudicated. Back in 2014, 15, and 16, we have noticed that because of the cap, the USCIS has expedited the cases where people are in the cap and adjudicated the cases even though we did not file in premium processing. But they are no longer practicing that anymore. This administration is quite different than the previous two administrations that I've seen.
Yes, so if it's not approved by September and premium processing is back, I would upgrade it.
Yes.
Do you think it's a good idea to downgrade from EB2 to EB3 right now? I'm assuming this is from someone from India.
Yeah. We have noticed that in China, EB2 gets first, then EB3, then EB2, then EB3. We have noticed that in China going up and back and forth. We have not noticed yet in India that it goes up and down EB3, but based on the discussion with the Department of State, we are expecting that it might go up and down, but I would not at this point of time downgrade my H1, my EB3 to EB2 to EB3 at this point of time, unless it comes to a stage where the priority date is current for me at that point of time. I can take a choice at that time. And there are also options that with the existing labor certification EMLI, even though we got the application approved in EB2, under certain circumstances, we can even file with the same labor certification in EB3. Under certain circumstances, we can do if we want to. But I wouldn't do it at this point of time, do that expenditure of doing it.
All right, we have a question about the timeline for the H-4 EAD rule. So remember, there is no rule yet. We're expecting a proposal, just a proposal, sometime in June. That could be delayed. The proposal generally will require a 60-day notice and comment period. So that's putting us in August. And then it could take a good 6 months for the Homeland Security to review all of those comments and issue a final rule. That puts us, what's August plus 6 months, sometime next year. And then once they do finally issue a final rule, it usually won't take effect for 60 days. So we're probably looking at another year before anything official takes place. And again, a lawsuit is pretty likely, which would likely extend things even further. So nothing imminent on the H-4 EAD other than a potential proposal next month.
Last time when they wanted to pass the H-4 EAD, it took almost more than 1 year for them to pass the H-4 EAD regulations. And also don't forget that Emily, in her blog of Immigration Girl, has collected a lot of statistics with regards to the H-4 EAD. We are well equipped in our office to support your H-4 comment when and if the proposed regulations are going to come. We expect that you're going to come to immigrationgirl.com and you're going to use the data that has been collected, you have provided to Emily Newman on her immigrationgirl.com, and then we are going to use that to draft a letter for you when the comment period comes in, we're expecting that you're going to comment on the H4 in a positive way where you wanted to continue with the H4 EAD. A lot of repeat questions.
Any thoughts on using the SOC code for a computer systems analyst for an H-1B?
Computer systems analyst was a sacred cow for a long period of time, since the time I've been practicing in 1995 all the way to 2017. Somewhere in September of 2017, the DOL, with regards to its interpretation, said that only 47% of the computer system analyst requires bachelor's degree. That has thrown the entire system upside down. Right now, they did taken off some of the alternative degrees in the DOL things, but it still is 47% degree requirement. Even though if it's a level 2 or level 3, I would be very cautious if it's a system analyst position. I will discuss with an employer to see, is this the only position that this guy is going to fit into? Can the employee do a different job than the system analyst job, maybe a software developer or some other job? So that would entitle a better chance of getting the H-1B approval. If the job description matches a software developer, I will go. Even a programmer, computer programmer right now, is much better chance in getting the approval than compared to the system analyst at this point of time.
All right, yeah, at this point it looks like everything is kind of repeat questions that we've already answered. So if you did not hear an answer for your question and you joined late, you may want to go back and watch from the beginning because we've probably already answered it. But thank you for joining. We'll be doing this again in 1 week on Tuesday, so stay tuned to Reddy and Newman's Facebook page. We have lots of information on our website as well, rnlawgroup.com, and you can visit immigrationgirl.com for updates and leave your comments and questions there.
Thank you again. We'll see you next week, Tuesday at 5 p.m. Central Time, all the time. Thank you.